How do you prove a company is still using trade secrets a court already found it took, after it claims a full redesign? That was the enforcement problem facing Motorola Solutions' legal team. After a jury found Hytera Communications misappropriated trade secrets and a court reduced the civil award to roughly $543.7 million, Motorola watched Hytera roll out a new line of radios, labeled redesigned. Labeled clean. The district court later saw something else. In August 2025, a federal district judge held Hytera in civil contempt on the redesigned H-series products and ordered roughly $59 million in unpaid royalties, plus about $11 million in interest, over $70 million on top of the earlier judgment path. That contempt order is not the same document as the 2024 Seventh Circuit appeal of the original judgment. One chapter is liability and damages. The next is whether a redesign still owed royalties under the court's orders. This ruling tested the power of post-judgment enforcement. Changing the product name was not enough. The court demanded a true purge of the adjudicated architecture, not a cosmetic shell. But to understand why the redesign fight mattered, we first have to dissect the original code itself. It wasn't a single program, it was a portfolio of proprietary technology for digital mobile radio, or DMR. Legally defined and protected as a trade secret under the Federal Defend Trade Secrets Act, this portfolio became a core technology in Motorola's public safety communications business. The secrets live deep within proprietary source code and thousands of pages of engineering documents governing the core operations of its high-end digital mobile radios. For police, fire, and emergency services, these aren't luxuries. They governed the functions that mattered most. The core software that ensured calls were clear, connections were stable, and communications were reliable in a crisis. They governed the functions that mattered most, the core operations of its high-end digital mobile radios. For police, fire, and emergency services, these aren't luxuries. They governed the functions that mattered most. Secure, military-grade voice encryption, dynamic channel management, and complex trunking protocols that let thousands of first responders share a handful of frequencies without interference or a single dropped call. They governed the functions that mattered most, the core operations of its high-end digital mobile radios. For police, fire, and emergency services, these aren't luxuries. They're the difference between a coordinated response and a radio going silent at the worst possible moment. This technical superiority created a moat that insulated Motorola's market position. The company had poured decades of resources into building, refining, and guarding this integrated ecosystem. It was engineered as a closed system, a fortress of code designed to be impenetrable. Its value came directly from its secrecy. The mission-critical communications market for public safety was built on a foundation of trusted, proprietary technology. But a fortress is only as strong as its gatekeepers. So the central question for the court became simple and damning. How was this guarded digital vault opened from the inside? No firewall was breached. No server was hacked. The vulnerability was human. Motorola's case centered on a targeted recruitment campaign by Hytera, which hired a wave of engineers directly from Motorola's own development teams. These were not junior staff. They were individuals with intimate, high-level access to the crown jewels of Motorola's DMR portfolio. According to court filings, this strategic hiring was the vector. The trust Motorola had placed in its most experienced personnel, codified in employment agreements, and a professional duty of confidentiality, was allegedly turned into a weapon and aimed back at the company that built them. These engineers, while still employed by Motorola, allegedly downloaded thousands of proprietary design documents and, most critically, portions of the protected source code itself. And the migration of talent, Motorola argued, was accompanied by a migration of data. These engineers, while still employed by Motorola, allegedly downloaded thousands of proprietary design documents and, most critically, portions of the protected source code itself. If proven, this was a catastrophic failure of internal controls and a fundamental breach of contract. It allowed Hytera to allegedly bypass decades of difficult, expensive research. The company wasn't accused of studying a finished product and racing to copy it. It was accused of walking off with the blueprints and the engine that made it run. But an accusation is not a verdict. With the code now sitting inside a competitor's walls, Motorola faced a formidable challenge. How could its lawyers forensically prove that its exact lines of proprietary code were now running inside Hytera's radios? The battle moved from the boardroom to the binary. Access alone proved nothing. Motorola's case now rested on demonstrating actual use, and that meant a meticulous forensic investigation into the code itself. Investigators and expert witnesses lined up the two companies, source code, side by side. What they allegedly found was stark, identical, often obscure segments of code, not similar function. Verbatim duplication, character for character. Proprietary encryption routines. Complex error handling sequences. And most damning of all, the same minor coding errors, bugs, Motorola's own engineers had made, allegedly mirrored inside Hytera's firmware. A copied program can be coincidence. A copied typo cannot. The argument was brutally simple. The odds of two independent teams writing thousands of lines of complex code in precisely the same way? Effectively zero. In the courtroom, that digital evidence became a story a jury could follow. Motorola's experts took the stand and presented the digital forensics. They showed how specific segments of code, complete with identical, minor coding errors, lived in both Motorola's secure development environment and inside Hytera's finished commercial products. The same crack in the foundation, copied into a rival's house. It formed a direct chain Motorola argued was unbroken, from the alleged taking of the data to its integration into a competing device. No room for coincidence. No room for a story about independent invention. The jury was convinced misappropriation had occurred. Therefore, the proceedings pivoted from proving civil misappropriation under the Defend Trade Secrets Act and copyright claims to pricing it. And now the court faced a far harder question. What is the precise dollar value of taken code? A jury's verdict came with a staggering price tag, an initial award of $764.6 million, later reduced by the district court to $543.7 million. Money was only part of the battle. The court also entered orders meant to stop Hytera from selling products built on the adjudicated secrets, and to force a clean slate choice: exit, redesign for real, or pay under court-supervised terms. Restore the competitive starting line the jury found had been broken. On that first track, liability, damages reduction, and the shape of injunctive and royalty relief, the parties fought through appeal. In July 2024, the Seventh Circuit issued its published decision in Motorola Solutions versus Hytera, reviewing the reduced judgment and related issues on the original case. That appellate chapter is about the $543.7 million civil judgment path, not the later redesigned contempt hearing. It was not the last chapter. Hytera returned with a portfolio of redesigned H-series radios, insisting they were scrubbed clean of Motorola's intellectual property. Motorola argued the new devices were still substantially like the products adjudicated at trial. In August 2025, the Northern District of Illinois held Hytera in civil contempt on that redesign theory and ordered roughly $59.3 million in unpaid H-series royalties, plus about $11.2 million in interest, over $70 million for the contempt track alone. New paint on a product, the court found, was still substantially the same. That contempt order sits on a different timeline from the 2024 Seventh Circuit judgment opinion. Liability first, enforcement second. The appellate judges and the district court, at different stages, kept landing on the same hard question. Where does a legitimate redesign end? And where does a bad faith end? Run around a court order begin. A $543.7 million civil judgment means little if a defendant can rename a product line and walk back into the market without paying what the court ordered. That is the real question this case forces open. Where does a legitimate redesign end? And where does a bad faith end run around a court order begin? Keep the tracks straight. The 2024 Seventh Circuit decision reviewed the original judgment path after the district court reduced the jury award to roughly $543.7 million. The August 2025 District Court Contempt order is a later enforcement chapter. The court found Hytera's H-series products substantially, like the adjudicated radios, and ordered over $70 million in unpaid royalties and interest. Judgment first. Contempt for the redesigned fight second. Those are related fights, not the same order with the same date stamp. The lesson cuts both ways. For rights holders, an injunction and royalty structure have to anticipate the workaround, not only punish the original misappropriation the jury found. Write the order loose, and you hand the other side a loophole. For defendants, a fresh coat of paint does not automatically clear a civil contempt analysis. When a court is willing to uphold a penalty this size on a redesign claim, it signals judges will pull products apart to the architecture, checking whether the adjudicated secrets were truly removed or merely hidden. The taint does not fade by marketing language. It has to be excised under the court's standard, which leaves one open question hanging over the industry. Does a brutal civil penalty for a failed redesign actually deter the next defendant, or does it just teach better concealment? Tell us where you land in the comments. If this breakdown of the Motorola versus Hytera case clarified the legal stakes, a like helps us reach more curious minds. Do you think the court made the right call on the redesign? Drop your verdict below.